Welcome to DRTSPR show. This is Dr. Tangella Shiva Prasad Reddy alias Dr. TSPR. Namaste, Adab, hello and a warm welcome to Ravichandran, Swaminathan ji. Namaskar. Democracy dying incrementally. It has become a rage over India. लोकतंत्र कहते ही थोड़ी आपत्ति स्थिति में है, लेकिन धीरे धीरे उसको खत्म किया जा रहा है क्या? हम जो आपातकाल परिस्थिति 1975-77 के बीच की हम बात किए थे, 1975 और 77 के बीच की, लेकिन अब 2014 से क्या हो रहा है, किस तरह हमारी लोकतंत्र को नाश विनाश कर दिया जा रहा है, इसका किसी को अंदाजा है? वही ने रविचंद्रन स्वामीनाथन जी ने हम अगले शो में यही कहा था कि लोकतंत्र को एक सवर्ण के बाद में और एक सवर्ण लाते हुए हमारे निजी स्वेच्छा को जिस तरह खत्म किया जा रहा है और वो लोकतंत्र की जो हम कहते हैं बात, उसको धीरे धीरे कहते ही पक्का खत्म किया जा रहा है। इसीलिए उन्होंने ये शब्द किया था, डेमोक्रेसी डाइंग इंक्रीमेंटली व्हेन पार्लियामेंट बायकॉट्स इन मेमोरी ऑफ what has happened in 1975-77, but why parliament is not discussing what is happening now? The amendments, so many amendments. Can anyone understand? Can at least parliamentarians, lawmakers understand how many lawmakers are there? Before we used to have parliament means lawmakers, those who understand law, and they used to discuss and pass legislations. And that too how? From panchayat level, municipal level, assembly level, discussions after discussions. Only Parliament used to discuss. But here, that is what Ravichandran ji, Swaminathan ji also last time also when we were doing a show, we were literally requesting Amit Shah and Modi ji, first before you pass, table it on the floor of Parliament, at least ask them to give it to you in Gujarati or in the language which you understand. Because what will you do after you leave the same set of laws if they try to utilize against the major community who have voted you? That is why you have been asking all those who have voted, become sensitive now. A small example, envelope jurisdiction, what Chidambaram has done in case of Amit Shah, when Amit Shah was jailed, the same envelope jurisdiction was applied to Chidambaram to send him to jail. That means there is no information provided to the accused lawyer or accused, but that envelope, that government public prosecutor will give to the judge and judge will say, remand him to the custody. This is what criminal laws, very criminally being utilized to settle scores. And what if the same is utilized to settle scores with Indians? Indians are the constitution. And Prime Minister to Chief Minister, they're all public servants. And then these new laws, I still don't understand the entire terminology in Hindi with due corrections. And even Supreme Court said they are going to put that into practice. All high courts, without even understanding the court officers, whether they understood this. English term in terminology, IPC, CRPC, Evidential Act, have been converted into what? They said 1905, 1958, 1972, British time laws. But why this is in Hindi again? Why are you imposing as a Southern Indian? I cannot understand beyond a point. Why should I? When I am studying in very different languages, this is what we have been crying hoarse. There is no common syllabus across India, whether it is NEET or anything. Now these laws also, same thing is applicable. Why are you imposing? At least now, Southern Indians will have to understand. Every South Indian has to learn. If my mother tongue is Telugu, I have to learn neighboring Karnataka, Kannada, then Tamil, then Malayalam. So if you are well versed, no one is going to disturb you. Ravichandran Swaminathan ji, before I show some videos.
Thank you, Dr. Reddy. Good morning to everybody. Dr. Reddy, there are 2-3 things I will start out with. First thing is, the language in the Supreme Court is English. It is not Hindi. The language to be used in the Supreme Court is English. So just because I write Hindi words in English does not make Hindi English.
Wonderful.
It still remains Hindi. And Indian Penal Code, that is the English code that we were being following for so long. It is Indian Penal Code. Penal is penalty, punishment. That is the meaning of that penal code. By changing it to Bharat Nyaya Sanhita, it does not mean that there will be justice. Just because you introduce the word Nyaya does not mean it is justice. One of the prime reasons for bringing this set of 3 laws, Bharat Nyaya Sanhita, Bharat Nagarik Suraksha something, and Bharat Sakshya Sanhita.
Adhinam.
So,
Adhin. See, this is
these three are being brought about, and the reason for bringing it is we are changing colonial laws into Bharatiya laws. That was the reason given. Now, between 1947 till 2023, there have been several law commissions, and each law commission has been recommending some changes in the laws, which have been implemented also.
amendments
Changes have been made into the original laws, which means what we are having right now is not colonial laws. It has already been changed. It is no longer a colonial law. It has already been changed by the various law commissions over a period of years. So, saying that we are changing colonial laws to reflect today's situation is not correct. That is point number 1. Point number 2, what has been done is you have not actually changed the laws. You have just copied it and pasted it, and some of the laws you have compacted it, some of the laws you have expanded it, but the laws remain the same. So you have not decolonized the laws like what you are claiming. You have only recolonized the laws. That's all.
Giving more.
It is not decolonization, it is recolonization of the laws. So, yeah, this is how laws, legislations are being drafted, and it has been very poorly drafted. Let me put it this way: I have gone through the entire thing. It has been very poorly drafted. It will give rise to a lot of issues as we go down the line.
During implementation.
It is not going to help anybody.
Yeah. Now, shall I play those 2-3 videos, what he has done?
Please.
I hope Amit Shah ji, I don't know whether both of any of Mr. Modi or Amit Shah has a law degree to their credit. Because without understanding, how can they pass without discussing anywhere? Who is behind them? Who is advising you? Amit Shah ji, ये ब्रिटिश की लॉस नहीं होते, क्योंकि सालों साल लॉ कमीशन बैठता है और हर बार सवर्ण हुआ है, और ये सब कुछ भारतीयता की ही, भारत जो जरूरी है, हर वर्ष में लॉ कमीशन 2 साल को या 3 साल को जो होती है, उसके द्वारा ही ये सब कुछ सवर्ण हुआ। मोदी और अमित शाह जी, पहले आप जिसने आपको ये करने के लिए कहा, उनसे पूछिए क्या है अभी भी ये ब्रिटिश लॉस है या सवर्ण हुआ हमारे भारतीय, और आप देखिए आप क्या कहते हैं।
माननीय अध्यक्ष, ये तीनों विधेयक दंड विधान प्रक्रिया, क्रिमिनल जस्टिस सिस्टम को बेसिक कानून, इसके लिए मूलभूत कानून ये 3 विधेयकों के अंदर है। एक है इंडियन पिनल कोड जो 1860 में बनाया गया, दूसरा है क्रिमिनल प्रोसीजर कोड जो 1898 में बनाया गया, और तीसरा है इंडियन एविडेंस एक्ट जो 1872 में बनाया गया। 1860, 1898 और 1872 में अंग्रेजों द्वारा बनाए गए, अंग्रेजों की संसद के द्वारा पारित किए गए ये तीनों कानूनों को समाप्त कर आज हम तीनों नए कानून पुरस्कृत करने के लिए मैं आया हूं। माननीय अध्यक्ष जी, इंडियन पिनल कोड 1860 की जगह भारतीय न्याय संहिता 2023 अब एस्टैब्लिश होगी। क्रिमिनल
अब देखिए, एस्टैब्लिश होगी। एस्टैब्लिश क्यों वो आप शब्द यूज करते हैं माननीय मंत्री महोदय अमित शाह जी? और इसी तरह जो एलोपैथी सिस्टम है, वो वेस्टर्न सिस्टम है, उसको भी आप खत्म करना चाहते हैं माननीय अमित शाह और मोदी जी? ये बताइए आप क्या करने वाले हैं आप शब्द देखिए क्या इस्तेमाल कर रहे हैं आप। इसीलिए मैं थोड़ा, क्योंकि ये व्यावहारिक भाषा है, हमारे भाव को प्रकट करने का एक माध्यम है भाषा। इस भाषा को लेके आप इस तरह की, आई एम राइट मिस्टर रविचंद्रन जी?
Yeah, yeah. See, this is just a play of words.
Sir. Yes, sir, you are saying something.
See, this is just a play of words.
Play of
Now,
words.
he says this is an English law enacted in 1860, correct? But this English law has served its purpose for the last 70 years without any issues.
And
you
many
have not
amendments.
changed the laws.
Amendments have been done, no, sir? Why he
Yes,
is not stating
amendments
that?
have been done. And what you have done is you have copied and pasted it. So in what way has it changed? Except the section numbers have changed. Just by changing the section numbers does not mean that you have changed the laws.
Yeah, I'll come back to that. Keep that in your mind, sir. Section numbers.
1898 की जगह भारतीय नागरिक सुरक्षा संहिता प्रस्तापित होगी और इंडियन एविडेंस एक्ट 1872 की जगह भारतीय साक्ष्य अधिनियम 2023 प्रस्तापित होगा।
And seriously, how many will understand this new? He is unable to spell it. They speak Hindi very well. With due respect to me, he himself is not able to utter those words properly. Can a common man do? Laws are framed in the interest of common justice system, which rescues the most poorest of the poor or commonest of the common. Am I right, sir? That is how our
Correct.
justice system is. Am I right?
Yeah, yeah. See, this is the issue, Dr. Reddy. This is precisely the issue. Number one, you use jargon. Number two, you use it in a language which is not understood by a large number of people. And number three, you claim that you are changing something, but actually you are not changing it. Just by replacing one word with another does not mean there is a change in the law.
Wonderful. So now let us hear what opposition leaders had to say on this.
Opposition leaders did not say anything. They just walked out.
Yeah, that's what I'm just trying to play. After that,
पक्ष इस कानून से प्रभावित हो सकता है, उनसे बात किए गैर मनमाने ढंग से जो तानाशाही पूर्ण तरीका है इस सरकार का रवैया है, उसी के तहत ये सारे कानून बनाए गए हैं और एक तुगलकी फरमान आज से पूरे देश में जारी हो रहा है।
ये जब 3 लॉज पार्लियामेंट्री स्टैंडिंग कमेटी में आए थे तो वहाँ के काफी एमिनेंट जो मेंबर्स ऑफ पार्लियामेंट थे, एक्सपीरियंस मेंबर्स ऑफ पार्लियामेंट थे, जो लीगल प्रैक्टिस करते हैं, उनने क्लियरली अपना डिसेंट नोट दिया था और बताया था क्या क्या उसमें चेंज करने की जरूरत है। पर उसको दरकिनार करते हुए ये लॉ तब पास हुआ है जब हिस्टोरिकली पहली बार 146 एमपीज, ऑपोजिशन एमपीज को सस्पेंड कर दिया गया था लोकसभा में।
These 3 new criminal laws which have come into effect from today are pernicious in nature. They are draconian in their implementation. They will throw a spanner in the works of the Indian criminal justice system. From today, 2 parallel systems will be in play. All those cases which have been registered before 30th of June, midnight 2024, will be prosecuted under the old system. Then all the cases registered after 30th June 2024 midnight will now have to be prosecuted under the new system. There are 3.4 crore cases which are pending in India's judicial system. A bulk of them are criminal cases. And so there's going to be utter confusion.
The CPIM has demanded that the government should not implement these laws. And there are two aspects to it. The first is the procedure, which was adopted by the government in the last Lok Sabha to push these laws, to bulldoze these laws, was done in the absence of a large number of opposition members who had been suspended from the Lok Sabha. There was no consultation either in Parliament, nor was it sent to the Standing Committee, which should have been done. And importantly, no legal opinion was taken. The Law Commission, it was done by the Home Ministry.
I think we have done.
Okay. See, Dr. Reddy.
Yeah.
Can I continue?
Yes, sir. Now you go ahead.
See, Dr. Reddy, this is the issue. 146 Lok Sabha opposition members were suspended. Why were they suspended? Because they were shouting in the well, because they were obstructing the working of the parliament, they were suspended. This is irresponsibility on the part of opposition. If they really wanted to discuss something, they should have stayed in the benches, followed parliament procedure and debated with the government. Walking out or running away from the problem is not the solution. This is not the reason why they were elected. Shouting and screaming in the parliament is not a debate or discussion. Preventing the treasury benches from talking is not discussion.
But the same was
The
done
opposition
by
must understand that.
last parliament. Same was done by treasury benches. They did not allow parliament opposition leaders to speak. Whenever they used to stand up, either speaker used to pull off the mic or they used to shout.
Sorry, I have to differ with you, Dr. Reddy here. The speaker does not have any powers to switch off anybody's mic. He doesn't have the controls at all.
Yep.
But I will not go into all that.
No, let
But
us
the
not.
point that I'm trying to make is simple.
They should
The
discuss.
opposition,
They should
the
discuss and
opposition-
deliberate.
what they are coming out and discussing, they should have been discussing it with parliament and they shouldn't be walking out.
Right. That's I agree, because they are elected.
That is a limited view that I'm making.
No. I'm for it, because you are elected. Let them speak for 4 hours. At least you will get 15 or 20 minutes time. You record it.
You record it, speak it, make your dissent clear. Then
you
you
come
have
out
got
and,
every right to come out and talk about it.
First you dissent in parliament and then you come out and lead a public agitation, because your voice is recorded there.
Yeah.
Yep.
So let it go on record.
Yes.
So now, after walking out of parliament, you can't come out and say that the government has not permitted us to talk. Only if you are in parliament, you can talk. So this is one aspect of it.
Right.
The second aspect of it is, I will go into some of the legal things and all that.
Now I wanted you to come from mere changing the language. Now everything is being done in English again. Those Hindi words are being written in Hindi, English. And the sections, the jargon of the sections, words, I mean numbers. From there, I think I want you to start from there.
See, just by changing the section numbers, you are not changing the law. The law is still the same. For example, I'll give you 124A Sedition Act. Now, this word sedition, see, this is the problem. The people who have formed this laws, Bharat Nyaya Sanhita and all the 3 laws, they should have read the constitution debates. They should have read the constitutional debates and they should have read how each section was debated by the Constituent Assembly before bringing these laws. Now, 124A talks about sedition. In fact, there was a big debate on use of word sedition. Some of the members felt that most of the members felt that the word sedition should be taken away, and instead of sedition, they should have introduced the words security and integrity of the country. Because sedition has got a different meaning. Today, sedition has got an additional meaning of saying that even if I criticize the government, it is sedition.
Yeah, that's what.
So if I do a protest in the streets, it is called, I can be booked under sedition.
Against the
So they
government.
didn't want the word sedition to be there in the statute book. Now, what the government has done is it has repealed that section 124A in the IPC and brought a new section 150.
Okay.
And in that, see, very cleverly what they have done is they have retained the words in the sedition without using the word sedition. They have retained the words in the law as per sedition, and they have expanded the definitions to cover terrorists and other antisocial, unlawful acts. They have expanded the meaning of sedition. That's all. And by expanding the meaning of sedition, they have brought in certain acts which can potentially be treated as sedition.
Okay. Jargon of.
Yes, just jargon. Now, additionally, what they have done is they have given the superintendent of police whether to apply the unlawful prevention act or the Bharat Nyaya Sanhita. Whichever act they want, the superintendent of police can decide. Earlier it was not that. Which means, and there is no checks and balances. This checks and balances in the IPC was the thing which kept IPC going so long. When the checks and balances have been removed, then what happens is your fundamental rights can be constrained, restrained, or overturned by an executive order.
So you mean to say they have already into planning that democracy, I mean, no more democracy will prevail in India?
The way it is now, whether they are planning to completely bring dictatorship or whether they want to destroy democracy, let us not go into that. But they have opened the doors for that. Today it may be this government, tomorrow it can be even Congress government, or tomorrow if today you have got one terrorist being elected to the parliament. What happens if that terrorist becomes a prime minister of this country? He will use these laws. He will use precisely these laws to put you and me behind bars along with Modi and Amit Shah.
Yeah. In different cells, please. Your video, sir. This is the danger. ये है आपत्ति मोदी और अमित शाह जी, किसने आपको इस तरह की कानून बनाने की या सवरण करने की आपको हिदायत दी है या एडवाइस दिया है? किसकी राय लेके आपने किया है? भारत को जोड़ना था, आप पंचायत से लेके चर्चा होनी थी, उस चर्चा में सब कुछ बाहर आ रहा था। आज देखिए किस तरह की आप एक सुपरनेट के हाथ में छोड़ रहे हैं। इसके पहले इंडियन पिनल कोड जिस तरह बताया गया, रविचंद्रन, स्वामीनाथन, आर यू देयर सर? ओह, ही हैज गॉट डिस्कनेक्टेड, ही विल कम बैक। सो जिस तरह आईपीसी को चेक्स और इंडियन पिनल कोड में चेक्स और बैलेंसेस थे, कोई विपरीत इस तरह की परिस्थिति हो वो कानून को लेकर, तो उसको संभालने के लिए उसमें और एक विंडो था और एक अवकाश था। लेकिन आप इस तरह की सवरण लाए जो है सब कुछ एक सुपरिटेंडेंट ऑफ पुलिस के हाथ में लगा दिया, अनलॉफुल एक्टिविटीज या तो एग्जीक्यूटिव ऑर्डर। इसका मतलब क्या है? पार्लियामेंट की कोई जरूरत नहीं है और हमारे न्याय व्यवस्था, कोर्ट की कोई जरूरत नहीं है। क्या कर दिया मोदी और अमित शाह ने आपने। और साहब, हर कोई जिसने वोट किया है, आप एक बार दोबारा पढ़िए ये कानून को, इंडियन पिनल कोड को, किस तरह ये एक एग्जीक्यूटिव ऑर्डर की तरह एक ऑफिसर के हाथ में लगाया गया। हाउ दे हैव ट्राइड टू पुट दिस टाइप ऑफ थिंग्स into the hands of an IPS officer. So that is why we were worried and scared. What if they are effectively implemented? What will happen to India? That is why we were trying to bring out a discussion which is not happening on the floor of the parliament. At least now opposition or in members, they should never leave the floor of the parliament. To record, everything should be recorded. Once it is recorded, government cannot go back. It has to send it to the standing committee, or it has to totally this amended 2023 acts, they have to be shelved once for all. This is the dangerous thing. So I could connect to Ravichandran and Swaminathan ji. He gave a very good example on IPC. What will happen to the IPC if you don't have checks and balances? From here, he will take. Yes, sir, Swaminathan.
I'm sorry.
No problem.
Suddenly the power got cut off.
It will, sir. It will, because when we are doing such an important show, it will. Please go ahead.
So this becomes an issue now. When you are opening the doors for any future people also to subvert the democracy. This is what you're doing, and you are not thinking about it when you're passing these laws. Just for example, police custody. Police custody was originally for only 15 days. Now, police custody can be anywhere between 15 to 90 days. It has been increased.
Nonsense. I don't understand.
But one condition that they have put is you have to seek police custody every 15 days. Police custody will be given for only 15 days, but it can be extended up to 90 days.
One and the same.
What is the point of this? Either, see, now there is a contradiction here also, because I will go to the contradiction later on. I'll talk to you about the contradiction when I come to it. Now, registration of FIR. Now the zero FIR concept has come. Zero FIR concept means I can register a case in any police station. I can submit the complaint in any police station. Okay, that is good. I agree that is good. Then what about jurisdiction? If the crime has been committed in Kanyakumari and I register a case in Chandigarh, who is going to do the investigation?
Yeah.
Are the Chandigarh police going to come and do the investigation? Or are they going to transfer the FIR to Kanyakumari police station and ask them to do the investigation? Okay, this is one part of it. And registration of FIR. FIR, police, law and order comes under the state schedule. It is not the central schedule. So, which means there is going to be a problem between the states themselves now.
Yes.
How can a crime committed under Tamil Nadu government's law in Tamil Nadu be registered in Chandigarh?
Yeah.
So, there is no clarification on that. Okay, you formed zero FIR, fine, I agree. But this concept of zero FIR should have been done in consultation with the states because they have got a stake in it.
Yeah.
Law and order is a state subject, not a central subject.
We have 10 minutes time, sir. Go ahead.
Now, this is one aspect. In FIR, a preliminary inquiry has to be done. Who is going to do the preliminary inquiry? Is it going to be the Chandigarh police or the Tamil Nadu police? And if you are going to do the preliminary inquiry and then register the FIR, there is another issue also, where cyber crime financial frauds are concerned. This I have already been talking about. Where financial frauds in cyber crime is concerned, you talk to 1930 and they immediately freeze the account. For freezing the account, an FIR is required. Now, if you are going to give the police do a preliminary inquiry, then do the FIR and then freeze the account, by the time you would have taken the money and gone away. Or if 1930 freezes the account on receipt of the complaint itself, they will be in violation of this law.
Contradicting their own.
No, it is now contradictory. It will delay filing of FIRs, and if you are going to do a preliminary inquiry, then register the FIR, by that time the accused would have run away. People like Malia or Nirav Modi, do you think that they are going to stay here when a preliminary inquiry is going on? This is the reason why they ran away, and you are not still able to extradite them. So this is another where there is a contradiction. You see, where there is a contradiction. Now, another serious thing, because now I have already come across 3-4 cases now. Sexual intercourse obtained through deceit will be penalized with 10 years imprisonment. Sexual intercourse obtained through deceit, that is if a promise of marriage, and if somebody has sexual intercourse on the promise of marriage, that will take a 10-year imprisonment. Now, what happens to the living in together relationship that the court itself has recognized?
Recognized.
So the woman can stay in a living together relationship, and if that man wants to leave and go, immediately she'll file a case saying that he has cheated me. He has promised to marry me. That is why I went into this. Where is this thing in this? Where is the logic in this? Today, anybody can say this. Anybody can say this. Today, any lady in this thing can say that, yes, that man has cheated me. He promised marriage. He had a sexual relationship. Now he has gone away. Now 10 years imprisonment. How do I prove that? So should I take it in writing every time that this is not a promise of marriage? Notarize it and keep it. This is absurd. Now, crime against women and children. They have increased the severe penalties have been imposed. Death penalty and life imprisonment. Okay, welcome. Fine. That is okay.
That implementation part.
Yeah. Will the judiciary give it? Judiciary says every sinner has a future. Yeah. Judiciary says that he has to be reformed. Even today, there is a Supreme Court. Even today, I saw that this thing in the case of one Ghulam Nabi, this thing where the Supreme Court says that the accused can be reformed. Therefore, the maximum punishment should not be inflicted. And this crime is committed by the accused criminal because of several other factors. That is, the accused is being forced to commit a crime. He is not doing it of his own choice. He is forced by economic conditions. He is forced by societal conditions and so on. So if you are going to give excuses to the accused, then why have penal provisions at all?
At all. That's what.
Remove everything. Tell the judge, okay, you decide how much imprisonment you have to give. Then why put death sentence, life imprisonment, and so on and so forth? Doesn't the victim have any rights or justice? तो इसमें किधर न्याय है? किसका न्याय है?
अमित शाह खुद आप बताइए, आपको जब जेल में लेके गए, यही लिफाफा एनवेलप का कल्चर था, चिदम्बरम ने अडॉप्ट किया. जब आप होम मंत्री बनते हैं, वही एनवेलप लिफाफा का कल्चर लेके चिदम्बरम को जेल में डाला. अब ये 2 उदाहरण, इतने बड़े उदाहरण है अमित शाह जी आपके साथ हुआ. आप किस तरह इसको पार्लियामेंट में आप टेबल किया है?
There is no logic behind this. No, statement of victims will be recorded through audio video means. Fine.
That is agreed.
Once I record it by audio video means, then I must require an expert opinion to say that the audio and video has not been tampered with.
Yeah.
So additional step has to be taken. Fine. Now, medical examinations are to be conducted within 7 days. Full stop. 7 days from date of occurrence or 7 days from date of reporting.
Full stop. They don't see matter.
Yeah, kidhar hai? Lady is being raped. She comes and reports immediately. 7 days. Okay, I can understand. Yeah. But if she gives a report after 1 month, then what is the point in medical examination?
Yeah.
Now, persons below 15 years and above 60 years are exempt from coming to the police station. Arey Baba, most of the rape cases are being done by people above 60 years.
And affected are below 15 years.
Yes, and affected are below 15 years. If both of them don't come,
also shamelessly,
how are you going to do the investigation?
Animals they are indulging. Yeah. It's a shame. Yeah.
And in the interest of trial, you have given 45 days. 45 days to file a charge sheet. For the kind information of this Home Minister, forensic examination reports comes after 6 months to 1 year. Forensic science examination reports comes after 6 months to 1 year. What is the point in putting a time limit of 45 days or 180 days? Where is the sense in this? Without a forensic report, how can you file a charge sheet? How can you run a trial? How can you run a case? ये दिमाग में नहीं आ रहे हैं इन लोगों को. Just for the sake of changing laws, you have changed the laws. So these are just a few of the points that I wanted to talk to you about. Technically speaking, they have not done anything new.
And they have complicated.
And they have complicated issues.
They have complicated and they have imposed Hindi. This is why we have been demanding in the parliament.
Just to give you one small example, Dr. Reddy.
Yeah, please.
Mahua Maitra has made a statement. You saw that tweet against the NCW chief, Rekha, saying that she was holding the pajamas of her boss. Now, this is a defamatory statement under Bharat Nyaya. She can be proceeded against Bharat Nyaya, this thing.
That means, yeah, you cannot even speak words to highlight the crime, intensity of the issue. So anything you speak, that means the freedom of speech, expression, Article 19(1) and so and so. That means there is a serious cap on journalism also, press reporters, as has been happening with telecom. So in a nutshell, our press friends, where are they? I don't understand whether it is academies or media houses, Press Trust of India. Where are you? One after the other, they are trying to see that the press freedom is once of all gone. Press freedom means 19 means freedom of speech or expression of a citizen. And I ask you directly, whether is this an act, amended acts, trying to take place, trial of courts? The trial of courts will be done by this executive itself now, or it will come to the court after. Will it come to the court, or there will be again compromises as we have seen, even MPs being elected unanimously?
So, see, forget about trials. Even if it comes to trial, I don't know whether the judges will be able to handle it, because this is absurd. Whether they have to do it in the old case or the new case, when how is they going to apply it? Under what sections are they going to apply it? It is punishment for cybercrime is given in IT Act. That is an old act. Now they are going to change the IT Act also as a Digital Protection Act. If they change that act, then this new act and the Digital Protection Act already it is confused.
Yeah. So it is confusion, imposition of Hindi, jargon of words and sections is nothing but it is an imposition which even court officers, lawyers will find it over a period of time. And I only hope the parliament will withdraw this in larger public interest to save democracy. Otherwise, it will be autocracy of the highest